Content warning. This episode contains discussion of murder and mental health issues.
On the murder sheet, we are always curious to learn more about issues at the intersection of mental health and the criminal justice system. Those topics come up a lot in some of the cases we cover. That's why we've taken the time to interview a slew of mental health professionals who spoke to us about their work with offenders in prison.
Now, we'll be hearing from an attorney who can give us a perspective on representing clients struggling with mental health issues. We were fortunate enough recently to get the opportunity to interview Timothy Sled.
Tim is the chief public defender at the Lawrence County Public Defender Agency.
Indiana's Lawrence County is in the southern portion of the state.
In this episode, Tim will talk to us about issues like competency, not guilty by reason of insanity, or NGRI, and guilty but mentally ill, or GBMI.
If you want to dig into the text of the Indiana Code yourself, Section 353611 defines insanity and mentally ill.
Sections 353621 through 353624 deal with insanity. Section 353625 also gets into GBMI.
Sections 353631 through 353634 focus on competency to stand trial.
And finally, Section 354136 contains the definition of mental disease or defect.
In this conversation, we're also getting into topics like the interaction between mentally ill individuals and the criminal justice system. Also, how society can better help such individuals before they commit serious crimes.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is Mental Health in the Criminal Justice System, a conversation with a chief public defender.
Can you tell us a little bit about yourself and your background?
Yeah, I am the chief public defender in Lawrence County, Indiana. Lawrence County is a small county south of Bloomington, Indiana. The county seat is Bedford. I've been the chief public defender here for just over a year. Prior to that, I was in private practice doing criminal defense work and family law work with a lot of mediation. Before that, I was the chief deputy prosecutor here in Lawrence County for 6 years. Before that, I was the juvenile law judge here in Lawrence County for 1 year. Then that takes us back to my burgeoning years as a young criminal defense lawyer in private practice doing contract public defender work. So almost my entire career has been trial advocacy and largely criminal practice, whether prosecuting or defending.
That is very interesting. It sounds like you've really kind of gotten experience in all sides of this.
In regards to criminal cases, I've been on all sides of the courtroom. I've been the prosecutor, the defense lawyer, the judicial officer responsible for handling search warrant cases, juvenile delinquency cases, which are criminal in nature. So I've had a good amount of experience in my 20 years of practice.
For folks who may not be acquainted with the American legal system in a very familiar way, given your experience, what's something that people may not understand about how our criminal justice system works?
So the American criminal justice system is based upon the constitutional tenet that the individual is to be protected from the government. Our Constitution had specific amendments put into it. One amendment allows people to be free to gather with whoever they want to gather with and worship according to how they want to worship and speak however they want to speak. Another amendment allows for people to possess weapons, and another amendment, Third Amendment, is designed to prevent the government from ordering soldiers in your house or being able to commandeer your residence for governmental purposes. The Fourth Amendment specifically allows for citizens to be free from unreasonable searches and seizures. The Fifth Amendment of our Constitution was for the purpose of preventing the government from making a citizen or an individual say bad things about themselves. My whole job relies upon the Sixth Amendment, which says that if the government accuses you of a crime, you have the right to have a lawyer represent you against the government. And that's where criminal defense lawyers and public defenders in particular draw their source of power. We have the Eighth Amendment, which says that the citizen is protected from cruel and unusual punishment by the government. So a lot of people, if you're just watching Cops, the TV show, or watching American movies based in law enforcement or whodunit murder thrillers, they often are shot from the perspective of law enforcement fighting crime, which is an important function in any orderly society. But our government, our criminal justice system says it has to be done right. The ends don't justify the means. We're going to have all of these different levels of protection in there for the citizen, every citizen, guilty or innocent. The government must operate through a higher burden, a strict and severe set of requirements that the government must heed to in order to be able to label somebody as convicted of whatever crime they're accused of. I think even Americans forget that 90-something% of criminal charges result in a plea agreement, not a jury trial, and that can cause people to think, oh, it's a foregone conclusion that if somebody is arrested and convicted, arrested and charged, that they're then going to be convicted. There must almost always needs to be a careful analysis of, did the government do it right? And that's what defense lawyers, public defenders, that's what we're doing, is we're taking these cases, we're throwing the cases through the filtration of the Constitution, analyzing the facts, comparing them to the statutes that are at hand, and then testing the state's case.
And part of the analysis is, of course, we have to determine the mental state of the person who is charged with an offense. And that's what we'd like to focus on today. One issue is whether or not a person is even competent to stand trial. Can you discuss what that means?
A person's mental health is very important throughout the criminal case. One of the basic precepts of our criminal justice system is that it's public in nature. There's not a star chamber, which was an English form of taking accused people into a secret proceeding, and then they come out of that proceeding convicted or not, and the people don't see what's going on. A criminal process is supposed to be very public in nature, and not only is it supposed to be public for purposes of the public seeing it, but it's supposed to be public so that the person who's going through it understands what's going on. And Kevin, you mentioned competency to stand trial. It is a very important component of our criminal justice system that a person is able to understand the nature of the proceedings that are happening, and it's conjunctive, it's not or, and that they be able to assist in the preparation of a defense. Indiana has codified, put into the law, the requirement of competency to stand trial. This doesn't mean this isn't even a question of whether or not the person and their mind state at the time of the alleged offense. This is when they sit in the courtroom. Are they able to understand what's going on, and are they able to help their counsel prepare a defense? Interestingly, in my 20 years of practicing law, this seems to be something that's happening more and more and more, that individual competency is coming into question. In the public defender realm, where folks tend to not have financial resources to address mental illness or to address medical issues or injuries, they are more prone to end up in situations where their competency is in question. And so when their competency comes into question, that can either be on the court's own motion, or it can be by way of defense counsel saying, listen, there's a problem here, Your Honor, and we need to address this. Then there are procedures that have to be followed to assess the person's competency and then move forward on their case, depending upon the outcome of that assessment.
One follow-up question that I think people do wonder with that is competency is not a sort of judgment on whether they were insane at the time of the crime. It really deals more with, can they help defend themselves? Is that right?
You're absolutely correct. Competency to stand trial is separate and distinct from an analysis of whether or not they had the mind state to commit the offense or the mind state to meet a defense of insanity, or a mind state to be guilty but mentally ill, which are separate and distinct. Competency is just a matter of, can we proceed forward with the case, because the person who's being accused has to be aware that they're being accused. They have to be aware of who the players in the courtroom are, and they have to be able to either formulate a cogent defense on their own or assist counsel.
And in terms of that, with competency, what is the process to determine whether or not somebody is competent to stand trial?
The process often begins with the defense lawyer noticing to the court that there's concerns and a need for a competency evaluation. And this is a very tricky place for defense counsel to be. I know that my colleagues don't take it lightly when they notice the court that there's concern about and a need for the competency assessment of a client, because the attorney-client relationship is confidential, and there's conversations that happen, there's analysis of evidence that happens. But when a defense lawyer raises the issue, that means the defense lawyer is probably at wit's end for being able to feel effective in moving forward. Another way, and this has happened a couple times just this year in my caseload, the person is so using the term decomposed, not in the sense of they're failing mentally to a state that it's abundantly clear to the court that something is up. And the court can, on its own motion, say, I'm going to issue a competency evaluation. Once the judge makes the order that a competency evaluation needs to happen, this is what the procedure is. Statute governs it, but psychiatrists and psychologists are ordered to go speak with the accused and then conduct an examination. And they have to be forensic psychiatrists and psychologists. And it depends upon what the level of the offense is. So if it's a murder offense, the qualifications and the number of people who are allowed to be involved in doing the assessment is different than if it was a theft or a possession of drugs or something like that. But then the judge orders a panel of psychiatrists or psychologists or a combination to go meet with the accused, the medical professional. They do a battery of tests and use different tools. They often review probable cause affidavits. They review medical histories. They get releases signed. They meet with the client, the accused. They do different screenings. One screening will be a mental health screening. One screening will be a malingering screening. A malingering screening is a way of trying to test the truthfulness of the person who they're interviewing. Sometimes they even review each other's reports. I have a case in front of me right now where the psychiatrist and one of the psychologists reviewed each other's reports before they submitted their final report, just to see if what they were experiencing was similar. So once the reports get turned in, there is a competency hearing. It's been the norm for me that the judge will subpoena the medical professionals to testify at the competency proceeding, and largely the judge controls the hearing. The medical professionals are the court witnesses, so subject to cross-examination by the state and the defense. and then the defense or the state can put on additional witnesses should they have them to either confront or agree with what the findings of the medical professionals are. When a person is deemed not competent to stand trial, then they are remanded to the Indiana State Department of Mental Health for competency restoration. And that means they go to a state mental hospital where they are then seen by medical professionals overseen, and it's a locked facility, and they are provided with medications and treatment and education on court processes to restore their competence. If their competence is able to be restored, they are then returned to the county where their charges are, and the case proceeds forward.
Experiences are what people love most about travel. With Viator, you can browse and book tours and activities so incredible you'll want to tell your friends. They offer everything from simple tours to extreme adventures and all the niche, interesting stuff in between. Viator has experiences in over 190 countries. There's something for everyone. Plus, Viator's travel experiences have millions of real traveler reviews, so you have the information you need to book the best activities for your trip. Viator lets you keep things flexible. Use Reserve Now and Pay Later to secure the activities you don't want to miss without being locked in. Whether you want to take a backstage tour of the Grand Ole Opry, a Miami Bimini Bahamas day trip by ferry, or a private guided tour of the Grand Canyon, Viator is for you. Download the Viator app now and use Viator 10 for 10% off your first booking. One app, over 300,000 experiences you'll remember. Do more with Viator.
Is it typical that a person's competency is able to be restored? And then what happens if it's not?
Great question. And the typical part, I'm not able to answer because I don't have the data. Mm-hmm. I can say in my experience and in my practice, yes, competency is most often restored. The length of time that it takes to restore competency has varied significantly. I'm struggling to think of a single case that I've had where competency hasn't been restored at some point in my experience. And I'm sure, and I know because of reading cases and reviewing the statutes, that there are cases where people are not able and are not going to be able to be made competent to stand trial. They then if somebody is not competent stand trial and unlikely to be made competent to stand trial, then they fall within the civil commitment statutes in Indiana, which require a person to be when they are involuntarily held in a mental facility. There has to be periodic reviews by the court. There have to be affidavits and testimony given by medical professionals averring or swearing to the fact that this is what needs to happen. And then depending on the type of case, if it's a low-level case, the person, if they are in the mental health facility, longer than the maximum sentence that would be imposed if they were convicted of the crime, then the court has to dismiss the case. So they would remain held under the civil statute for involuntary commitment, but their criminal case would go away. I've seen that happen on 2 different cases in the last year where a person's competency was restored, but by the time they got back to the county for processing their criminal case, they had essentially served more time, both pre-trial, in jail, and then at the state hospital than what they would serve if they got convicted. And Indiana has a case, I think it's Gross versus State, which instruct courts to dismiss in those circumstances.
Another one of the mental conditions or state that courts look at involves not guilty by reason of insanity. Can you discuss that and what exactly it means?
Yes, not guilty by reason of insanity. And in one of your prior episodes, you had a mental health professional come on who did a fantastic job of saying that insanity is a legal term, not a medical term. And in Indiana, insanity means the person was, and that's very important to say, was unable to appreciate the wrongfulness of their conduct at the time of the offense because of a mental disease or defect. And pausing on each one of those as I did that was important because every one of those words has been litigated and defined and broken out. But the analysis that we're looking at when somebody is asserting the affirmative defense of insanity, they're saying that the person's conduct that is now being called criminal by the government isn't criminal because they didn't have the ability to appreciate the wrongfulness of their conduct. And what that goes to is in Indiana's law and in most of American jurisprudence, something can't be a crime unless there's a bad mind. And they call that mens rea. The bad mind can be, you can be recklessly engaged in certain conduct, but you need to be engaging in that conduct recklessly, knowing that you know what you're doing. It might be reckless that you're doing that. I'm trying to think of if I were to be carrying around an old Renaissance style mace, a handle with a chain and a spiky ball on it, I'm swinging it around over my head. If I'm alone in a field, that's no big deal. But if I start walking through a building doing that and somebody gets hit, there might be a way that somebody gets down being reckless. I know I'm swinging a mace around. I know the dangers of a mace, but I don't intend to hit anybody. And there are different levels of mens rea. The highest level of mens rea is intent. I have the specific intention, the specific purpose of an outcome occurring. That's intending to do something. There's knowingly is another level of mens rea. That means that I am aware of a high probability of the outcome of my conduct. There's recklessly. And so there's these different mens rea, but that mind is something that the state has to prove. They have to prove on whatever the crime is. They have to prove the specific mens rea for that crime. Well, insanity is saying you can't prove that a crime occurred just because something bad happened. You have to prove that something bad happened and that the person had the requisite bad mind for it to occur. And insanity is saying they weren't able to appreciate the wrongfulness of their conduct, and they weren't able to appreciate the wrongfulness of their conduct because of a mental disease or defect. And so that's what insanity, the insanity defense, or not guilty by reason of insanity, that's what it is in a nuts and bolts sense.
So now no one's ever going to go with you to a Renaissance fair, Tim. But
they probably couldn't.
But with so basically insanity would be you take a mace and hit somebody, but you sincerely thought it was a dragon and that you are Richard Lionheart, King of England, essentially.
That would be spot on. In such a well, I guess then I would say then that would be true if there's one more point. That what is resulting in me thinking I'm Richard the Lionheart killing a dragon is a mental disease or defect.
Right.
And that's where the assessment, much like in competency, and sometimes in concert with a competency evaluation, is an insanity defense examination. The mental health professionals are measuring what is going on with this human being. And are they suffering from a mental disease or defect? A person can think that they are Richard the Lionheart and be delusional not because of a mental disease or defect. And at least in Indiana, they don't get to avail themselves of that defense.
Can you talk a little bit about the process that's undergone to determine if a person truly is not guilty by reason of insanity?
Yes. And I believe you're probably asking me, what do I know about the forensic examination component that goes into that? The forensic examination for not guilty by reason of insanity assessment does spend a significant amount of time looking at police reports, witness statements, probable cause affidavits, pictures of crime scenes. The mental health professional, who is not a detective, who is not a police representative, have to engage in an analysis of what the evidence is, because they're looking at and trying to figure out what was this person's mindset at the time of the offense. And Things that they may be looking for are, were there indicia of cover-up? Did the person flee from the scene? Did they try to hide evidence? Did they try to hide a body? Did they take trophies? There's all of these different things that the mental health professionals are looking at that would cut against somebody's inability to appreciate the wrongfulness of their conduct. Identifying a mental disease or defect may be very easy, but the mental disease or defect must cause an inability to appreciate wrongfulness. So they start with looking at the scene and say, is there something here where the person's ability to understand that what they did was wrong is apparent? If you feel like you're killing a dragon and slaying a dragon, you're probably not going to hide the weapon with which you killed the dragon, nor hide the dragon's body, nor change your clothes quickly and speed away in a car and not tell anybody. Versus if you believe you've killed a dragon and you take the blood of the dragon and smear it across your naked body while you're standing on top of the dragon and tell everybody come around and look at the naked dragon. Those are two different sort of behavior patterns that say something different about the person's ability to appreciate the wrongfulness of their conduct. And then from there, it appears through the reports that I've read for both clients and other cases that the mental health professionals measure what mental disease or defect might this person suffer from, and could that cause the same behavior.
I'm curious, the one aspect of this that we haven't really talked about is the guilty but mentally ill. And I know you referred to it as the loathed GBMI. Can you tell us a bit about that?
Yeah, the loathed GBMI. And I think it's loathed in the sense of those of us that practice trial practice and take forward an insanity defense because we believe our clients lack the ability to appreciate the wrongfulness of their conduct because of mental disease or defect. The guilty but mentally ill option is an option that the court can give to a jury for a potential outcome. And what can't be discussed with the jury is what do the differences in those outcomes actually mean for the defendant. A guilty but mentally ill result from a trial verdict is that the person gets sentenced as if they had just committed the offense. Now, the judge has a few extra tools and can make some other recommendations, and there is the option of submission of the convicted defendant to the mental health, the State Division of Mental Health and Addiction. But the long and the short of it is that the court shall sentence the defendant in the same manner as if the defendant had been found guilty of the offense. Juries are interesting. They are unpredictable. And in cases that go to trial where insanity is the defense, sometimes there are horrific fact patterns and horrific images, and juries hear not guilty by reason of insanity or guilty but, mentally ill. And there's just an extra layer of having to be able to differentiate for a jury whether the state has met its burden of what was the defendant's ability to appreciate the wrongfulness of their conduct. Because guilty but mentally ill presumes they're guilty, that they had the bad mind, they just suffer from a mental illness. They intended to kill the person, not the dragon, but they are mentally ill. If you're guilty, you have the bad mind, you did the bad act, then the law presumes that you will be punished or you will be sentenced, I guess. To me, it's punishment, sentenced in the same manner as a defendant who is guilty but doesn't have the mental illness. And in Indiana, we have specific factors, aggravating and mitigating circumstances that courts must weigh in determining what sentence is appropriate for a defendant. And mental illness and disease and defects are within that category of calculus for the judge anyway. So to have guilty but mentally ill it's scary for trial lawyers who are going to be trying an insanity case. But guilty but mentally ill does provide an option for cases that you may not want to try if there's a split between the mental health professionals on what the person's ability to appreciate the wrongfulness of their conduct was, if the facts are stacking against the success of an insanity defense. Guilty but mentally ill allows for a defense lawyer and a defendant to be able to sort of prime the pump at a sentencing for A, acceptance of responsibility, B, a delineated and defined set of facts that are addressing the severe mental illness of the client, so that when we get to the mitigating circumstances at trial, at sentencing, when we get to those, there's an extremely clear record that the court can then consider and hopefully, in seeking rehabilitation, direct the person to someplace other than the Department of Correction for those services. But when I say I loathe it because it feels like a compromise, and you don't want, in a case where somebody is validly asserting the insanity offense because they were unable to appreciate the wrongfulness of their conduct, they have the mental disease, mental illness, mental defect necessary to assert that. You don't want the jury to say, well, I don't think the state won this slam dunk, but I also don't think this person's not guilty because clearly there's either a body or an injury or a victim of some sort. So I'm going to split it and go guilty but mentally ill, because the result is significantly different. When somebody's found, and I believe in a prior podcast, your guest talked about, what happens after somebody is found not guilty by reason of insanity, but just a real quick synopsis of that. When they're found not guilty by reason of insanity, they are then civilly committed, and they have to go through a process through the State Division of Mental Health and Addiction for their reentry, if ever, their reentry into society. It's civil, not criminal. It can graduate, or a person can stay within the Department of Mental Health and Addiction for the remainder of their lives. It depends on what the level of their mental illness and defect is and whether it can be remedied.
And for GBMI, how can that look a bit different in terms of the outcome for the offender?
Yeah, so for GBMI, if we go to an analysis of, me at a Renaissance fair swinging a mace and maybe even swinging it at somebody and injuring them, aggravated battery, let's say, and I'm found guilty but mentally ill, a judge has a couple different options. The judge could put me in the Division of Mental Health and Addiction. But most commonly what happens is I'll get sent to the Department of Correction with a recommendation from the judge and a finding of guilty but mentally ill, but a recommendation from the judge that I be treated for my psychiatric condition. The fear that a public defender has is that the Reception Diagnostic Center has to process that judgment of conviction. So while I'm at the Reception and Diagnostic Center, am I being provided medication that may have already been started for me through a competency restoration? Am I being provided with the counseling and care that I was receiving if I was out of jail and treating my mental health needs and stabilized enough to be tried, and now I'm going into the Department of Correction without those? And where are our folks who go into the Department of Correction, where are they being treated at that level? And I think the answer is there's not a specific place where they are. So I would have concern for my client on a DDMI that, they may receive some extra care, but it's still going to be far, far less and far less compassionate than it would be if they were in the community far less, even significantly less compassionate than if they were in the Division of Mental Health and Addiction. Because if it was an insanity defense, they're not going to walk out of the courtroom after an insanity defense and drive home. They're going to go to the Division of Mental Health and Addictions and be in a state hospital until they're able to be graduated out. So, the fear is that they largely just become Department of Correction inmates. And I'm not sure that I don't believe that there's any mental health infirmary within the Department of Correction that would specifically handle these sorts of folks. I would have concerns for my client with a GBMI verdict or plea that they would need to be prepared for some significant decomposition, some significant further failing.
I'm pretty certain there's probably some people in our audience who might take the attitude of, why should we care about the mental health of a defendant? Why should we not just focus on whether or not they did the crime with which they're charged? Can you address why it is important to care about the mental status?
Yeah, absolutely. The importance that our legislators have put into defining what is a crime, because one of the things you said is they're going to say, why do we care about the mental health of an individual who has committed a crime? What makes something a crime is not just that a bad outcome happened. And I'm trying to think about a situation. I can think about one like this. If you're driving down the road in a neighborhood and a child darts out in front of your car and you hit the child, a bad result occurs. The child is injured or killed. That doesn't mean you committed murder. You can change facts about that exact situation that will change whether or not a crime was occurred. So you have the just true accident that occurs, an unforeseeable event of the child running out in front of your car while you're operating it at a valid traffic speed within your lane, without distractions, without texting and all of that. A true accident happens. Then you have situations where, let's say you're texting and you're driving and a child runs out in front of your car and gets hit. Well, now maybe you were driving recklessly and the mind there is reckless, and the bad event that occurred may have been able to be thwarted if you had not been texting. So perhaps there is some criminal culpability there, but it's not murder. It's a vehicular. It could be a number of different crimes that fits into, but it's more reckless. Let's say you are sober-minded, but you're behaving very badly, and you're driving in a neighborhood with school blinker signs going off that it's time for school to be let out, and you're driving through a neighborhood that has a normal speed limit of 30 miles an hour, but you're going 90 miles an hour, and you're weaving side to side. You are not intending to hit any children, but you're making it a very, very highly probable situation that if children are in the road, you're going to hit them. Well, that's another offense. And then you've got the Waukesha parade guy who just drove through a parade from behind. He intended to hit those people and swerved to hit people. There were lots of sort of conscious things that occurred that he was doing that show his specific intention to hit somebody with a car, and that's murder. So then to go back to your question, so the crime, something being a crime, has to have that mind attached to it. And why do we care about mental health is because we, as a civilized society, don't punish an outcome. We punish a crime. We punish the mind that goes behind it. If somebody does not have the requisite mental state to have committed the offense or to have appreciated the offense to the level of somebody of sound mind. We as a civilized society don't hold them to the same level. Doesn't mean that the injury didn't happen to the victim. Doesn't mean that it wasn't a horrible set of circumstances. But we have by the nature of the definition of crime and of each crime, an analysis of the person's specific mind. Those who may say, well, we shouldn't. We should just look at what happened. You can simplify this down just a little bit more to an analogy of maybe parenting. If your child is clumsy but doesn't have bad intent and spills milk on the dinner table and it runs off onto the floor and it wasn't because of misbehavior or anything, you're probably going to help the child clean the milk up off of the floor. But if the child in a temper tantrum or a tirade picks the cup up and pours it onto the floor, those are two different events that will likely cause two different parental responses. And we don't want to throw the first situation into a governmental response that's more appropriate for the second situation. Does that help or make sense?
Absolutely.
Yeah. I'm also curious, what kind of things do defense attorneys like yourself do to protect the rights of mentally ill clients? And what are some of the challenges you face in that?
I really appreciate that question because it's one that I suffer over when I run into situations where I have a client with a mental illness, because I believe in the attorney-client relationship so deeply that sounding the alarm of competency, sounding the alarm of an insanity defense is a big deal. In sounding the alarm that we are going to assert a not guilty by reason of insanity defense, you are subjecting your client to an interrogation as the facts of the case. Somebody else is going to be talking to your client about what happened. And so there should be very little dispute about your client's at least actual involvement in whatever the bad act that they're saying happened. Because if there's question as to whether or not your client was even involved, when you raise the insanity defense, you're tipping your hand that they were involved. They just couldn't appreciate the wrongfulness of their conduct because of a disease or defect. So you're exposing your client to knowledge, system knowledge, maybe not jury knowledge, but the system, the prosecutor and the judge at that point are going to say, okay, we know it's not a whodunit at this point. It's a why did it happen or how could it happen case versus a whodunit case. With competency, it's been my experience that folks that don't have an insanity defense as an option, but have competency and issues that arise later, after they've been arrested and incarcerated, there often is a regression back to the mean. So they were fine when they got arrested. They go to the jail. They spend 20 or 30 days in the jail off of the medications that they were on when they were on the street, or the drugs that they were on when they were on the street, and they decompose. But then the jail doctor, psychologist gets them on some basic medications, and then they regress back to a mean. So it's very difficult for defense lawyers to know when to pull the trigger on a competency. For me, it's when I am not able to work forward in a meaningful manner with my clients on strategies. Like, hey, I need you to watch this video with me. I need you to look at this plea offer. We need to talk about who are we going to depose? Who are we going to call as our witnesses? And it's a heavy analysis that has to happen to say, we're not getting anywhere, and we're not getting anywhere because you don't like me, or we're not getting anywhere because it's not because you don't like me. It's not because of these other things. It's because not able to communicate with me. Almost, I'm trying to think of, there's been an exception. I filed competency on several clients, but I've never had one get angry at me because they were so incompetent they didn't know that that's what was being done. And I think that's kind of a threshold question that I ask myself is my client going to be angry with me that I'm filing a request to have their competency evaluated? If so, they probably understand the nature of the proceedings to a certain extent. And then their ability to assist in the preparation of their defense is a whole nother question, because it's a two-pronged question. Is, do they lack the ability to understand the proceedings, and are they able to assist in the preparation of their defense? The balance that defense lawyers are going through in working with clients who have mental health conditions is wondering how severe they are, how impactful the mental illness or condition is, and what is the exposure that this brings your client to, and how can you operate in their best interest? Are there ways to negotiate the case in some way that you could get a dismissal and your client gets out and you don't have to go through this process? Or, if you're dealing with competency, you can't negotiate plea offers because if they're not competent to proceed, you can't have them sign agreements. So you're hemmed in to a certain extent on what you can and can't do for the client ethically. And so it's a difficult and it can be very frustrating because in my experience as a public defender, my clients who are in this situation are incarcerated, and they're often in seg cells because in general population, they get victimized, they get stolen from, they get beat up, they're causing scenes. And if in some cases where I have questions about what's going on here and I'm not sure what I want to do, I do have the ability to hire somebody to come in and do a forensic assessment for me before I notice the court. That way I can make sure that I'm not spinning my wheels in mud.
That makes a lot of sense. And I liked what you said about, in terms of competency, if someone is there enough to be offended that you're saying they're incompetent, that's a good indicator that they might have some sort of grasp. But somebody who is, maybe really struggling wouldn't even think about it that way.
Yeah, I've had at least one client that we did the competency for. We had a full competency hearing, and the person did not know anything about what was going on. And then I have had another client who was operating in different stages and states of delusion that understood the nature and the proceedings of what was going on, but was just in a completely different world and professed competency to the court, but yet was then also asserting certain defenses that are completely impossible, impractical, and untrue. And so it was that's why it's a conjunctive. That's why it lacks the ability to understand the proceeding and can assist in the preparation of a defense, because the assist in the preparation of the defense was completely subject to, and this was supported by the medical professionals that did the assessment, such a deep state of delusion that though this person was able to operate within the realm of knowing that there's a judge and there's a prosecutor and there's a defense lawyer, was not understanding that they were present necessarily on this planet.
One question I had is that I know a lot of his listeners have asked us with this subject, about the possibility of malingering, somebody faking mental illness in order to get preferential treatment. That's sort of seen as something that could potentially be a problem by lay people. In your experience, how does malingering factor into it? And is it common? Is it something that's easy to find out and put a stop to?
Well, I think it's probably more common than what a lot of lay people and lawyers may even be willing to acknowledge. I've had extensive experience with mental health providers forensic mental health professionals finding malingering in a case that I firmly believe it's not. There's not malingering, but the tools and the method and the assessment that was done by the medical professionals unanimously, 3 of them found malingering. and they use a tool. They use various tools, but this was a very long process with, competency, sanity, evaluations being done over a period of a couple of years. They use a specific, and I was looking for it in my notes, and I just can't find it right this second, but they use a specific tool. The psychiatrist used a specific tool that measures malingering, and they unanimously found that because of the words that the client used, the way the client used them, the screen that was conducted, they were able to say, no, this person is just trying to impede the prosecution of the case. It was a little shocking to me because there were things that my client would be able to do or say that I've tested, some of my friends and colleagues with similar sorts of, I've given them opportunities to see if they could perform the same way, and they couldn't. And so I was convinced that there was something going on, and that it wasn't malingering, but ultimately the conclusion of mental health professionals and then of the court was there was malingering. So I think, to answer your question, how often does it happen? I think cornered human beings are capable of being very defensive, just like any cornered animal. And one of the mechanisms of humans that we have is we have the ability to, use our psychology to help us out of cornered situations. And people who are in trouble they may try to do whatever they can do to minimize the trouble that they're in. I mean, it's the utilitarian notion of people will seek to maximize their pleasure and minimize their pain. And I tend to believe that. So I do think people will feign illnesses to try to get out of jail. Oh, I've got cancer. Or, oh, I've got congestive heart failure. Or, oh, I guess it could go, you can even go remotely. They can say, oh, my mother has cancer. Oh, my mother has congestive heart failure, and I need to be home with them and care for them. I hear that quite often. Then you have people that can say, no, it's me. I've got congestive heart failure. I've got cancer. I need to be out of the jail for this reason or that. But those are easily determined things. That's a doctor's appointment and blood tests, and even the jail nurse and medical professionals can quickly find that. What is harder for somebody to say is that you don't have anxiety, or you don't have bipolar, or you don't have latent schizophrenia or schizoaffective disorder or something like that. So if a person alleges that they have one of those conditions, malingers that they have one of those conditions, it's harder for a layperson and maybe even their defense lawyer to disqualify that. So I do think that makes some of these more prone to being utilized by the more manipulative and more savvy defendant. But there again in lies is how manipulative and how savvy are most defendants. So that's the good news is that's why the statutes require that that disinterested psychologists and psychiatrists conduct these examinations. As I was, preparing to speak with you, I pulled 3 of my cases from this year where competency or insanity was measured, and largely the same names of the medical professionals, some variation, but not much. And, I look at the tools they use. I look at the methodology they use. And only in one of the cases of these 3 did they find malingering. And that was after a significant re-examination. When they felt like malingering was occurring, they went back and conducted further examination. They were very careful, especially the psychiatrist was very careful to find out what was true and what was not true about the client's mental health condition. But ultimately, the conclusion was that despite the mental health conditions that this person has, the symptoms that were inconsistent and inconsistently described and reported by the client weren't medically known to be consistent with the conditions that the defendant had. And in the other cases, they they did not find malingering, and they used the screen to sort of tip the hands there. But yeah, malingering is a concern. It's a concern that I have. If I have the concern that malingering is going on, rather than file for competency or insanity, I tend to utilize a professional of my own first, secretively, so that I can know what I'm up against and whether or not I even need to go down that road.
In your view, does the system do enough to protect mentally ill defendants? Are there things the system could do better?
So the pause that I had there was to try to figure out what are we using and defining as the system, because if we just talk about the criminal justice system, the cops, the courts, the prosecutor, the jails, the prisons, are there adequate protections in that? I would have to say, hesitantly, I would say yes. I mean, the legislature has given us the tools we need to trigger assessment, to trigger placement in the Division of Mental Health and Addiction when necessary, the mechanisms to transition from the criminal justice process to the civil commitment process. So academically, I can look at this and I can say, from the criminal justice system, we have the statutory tools. But if we're going to look at the system and say the system of our state mental hospitals, the system of our hospitals in general, like our normal medical ER hospitals, the system of how we care for unhoused people, we are way failing. I mean, significantly failing in how we care for people with mental illness. The criminal justice system is not meant to be our mental health system. And right now, it carries the weight for the mental health system, whether that's addiction and the intersection between addiction and crime, or if it's people with significant mental disease and defects who aren't able to function in public, they end up in the next best place, which is jail. And that's just not true. Jail is not the next best place for people who are suffering from significant mental illness. In poor rural areas, jail is significantly more likely the outcome for somebody than an inpatient facility at a hospital. And that's true for Bedford and Lawrence County. I know of at least 3 clients this year that went for help to the ER at a hospital and ended up arrested. And to me, that is abhorrent. It's just very sad. And these 3 folks that I'm talking about were folks that ended up needing competency evaluation because they weren't able to understand and appreciate what was going on at their initial hearings. They were in horrible mental health state, and they hadn't hurt anybody. They had gone to a hospital for help and made a scene, or were unable to be cared for by nurses and doctors, and then hospital police get involved, and it devolved from there. I was at a conference in October, I think, of last year, down in Indianapolis, where this 988 initiative was being talked to by the 3 branches of our state government, which is an initiative to try to remove mental health cases from the criminal justice system by giving people a number to call, a person to talk to, a place to go, and to keep them out of necessarily the ERs and keep them out of our jails. But I know this is a long-winded response to Kevin's question, but I think as a system, our criminal justice system should not be taking care of mentally ill people, and we have the tools for when they do come into our system. But I think our governmental system, our medical health system here in Indiana is inadequate, and people are directed more often into the criminal justice system because of their mental illness than what we have as for long-term mental health inpatient care. We got rid of that some years ago within the state, and paying the consequences.
Oh yeah. It's absolutely abhorrent that essentially the solution to issues within, traditional asylums was to close them down and then basically provide no alternative for people who are struggling. And,
Yeah.
Unfortunately, you can see the effects of that all over. One question for you, and this is just given that you have the experience as a public defender, but also as a prosecutor and also as a judge overseeing juvenile cases. Are there things, and you kind of answered this already, so I apologize if it's a bit repetitive, but are there proactive measures that we as a society in Indiana and maybe even beyond can take to make it so that people who are vulnerable mentally are not even getting to the point where they're having to be processed in the system, where perhaps they can receive the help they need before it gets to that point?
Sure. I think the panacea that I have for this would be if we could just jump 20 or 30 years ahead into the 988 vision that was given a year ago, which is, somebody who is in a horrible state of mental illness and crisis, or a horrible state of, addiction, they've overdosed, or they're in public and found to be tweaking or something like that, isn't lock them up, but it takes them to another facility that then processes them through with medical care, mental health care, housing care. And I preface this with saying it's a panacea. I mean, I think we are a long way from it. But there is a need and a desire and an ability for us, because we can tell that this work when people have the means, if people are able to get consistent and regular medical care, are able to get consistent and regular medication, and are able to be counseled and talked through their mental health condition, then they are able to thrive more than if they're poor and they don't have the ability to get regular medical care, regular medicines and medication management, and to see the same therapist in and out again. Those folks tend not to persist with their care and their treatment. And so I think that encouraging our legislators, encouraging our friends and family to not view mental health as crime, and not viewing mental health as laziness, and not viewing mental health as poverty, but viewing mental health as a basic need, a basic care that we should do as a civilized society, and therefore, encouraging minimal. I mean, even if we had minimal public mental health services, it would be significantly better than what we have now. We don't have basic minimal public health services. We have nothing. And I know that there are people out there who say, well, what about like Centerstone, and what about these are agencies that get governmental funding, but they're not even minimal mental health services. They're underfunded, they're understaffed. We are in a stage of crisis, I would say, to where there are too few mental health providers out there, regardless of level. And to one of the factors that I didn't get in with when Kevin says, how is our system doing? One critique of the system is to get a competency evaluation done can take 6 months now, and that may be fast. I had a woman who presented at an ER in a state of decomposition. She was not engaging in crime, but she was able to be arrested for a Class B misdemeanor, which is has a maximum sentence of 180 days in jail. And with a B misdemeanor, you get good Class A good time credit, which means the most she could possibly serve is 90 days. She went to jail. She was not able to, this is a person that I've known for a very long time. She was not able to recognize me, didn't know that I've been around her a lot, and many conversations, many meetings. And so I filed for competency. On the 88th day of her incarceration, I noticed the court that the maximum time she could be incarcerated was going to pass within 2 days, and we needed to have a court hearing. And the judge dismissed her case, and she was released from jail without a competency evaluation because not a single medical professional had had the opportunity within that first 88 days to come see her and do an evaluation. That's abhorrent that we have so few forensic mental health professionals or mental health professionals in general to come do a basic competency evaluation. They're so and it's not because they're lazy. Trust me, I know 3 of these folks that do these forensic competencies. I know them well, and they are working hard and diligently, but they're in 92 counties. And there are many courts and there are many jails that are all experiencing the same crisis right now. And there's too much work, not enough mental health professionals to be engaged. So we have a problem, and for the practitioner out there, it's a tough road to navigate. For the citizen, the spectator, the person out there in the community that's saying, "What's going on? Why is this happening?" It's a crisis. A lot of jails are full right now, and a good amount of the population of the people that are in there have a diagnosis of some mental health condition. That doesn't mean they're not competent, doesn't mean they were insane, doesn't mean they were guilty but mentally ill. But there are a lot of people in our jails that have a significant mental illness. As you folks know, and the true crime genre knows from watching the cases more and more and more that we can watch them on the internet, on TV and whatnot, it's complex. It's confusing. It's scary. Imagine it's your life. We're in a movement in the legal profession where we're starting to use plain English in the courtrooms again, which is nice. But even if we use simplified plain English in the courtroom, it's really confusing. What is a preliminary hearing versus a pretrial conference? What is a motion in limine compared to what's a jury instruction? And as defense counsel, we are educating our clients all along the way as to, what's a motion to suppress, what's a deposition, what are all of these options. And some of the audience will have heard those words and not know themselves. Imagine if you were without the ability to Google it. What if you imagine you were within a jail cell and you feel like you don't recall anything that happened because you were in a complete state of delusion? What if you have severe anxiety disorder and you are now without your meds and you're in jail and you're accused of something, and the person who the court has assigned to see you has another 130 cases on their docket. So they get 30 minutes with you a week to help you address the crisis of your life. Mental health has a huge impact on my clients, and through compassion, trauma on me as well.
Absolutely. We just want to say thank you so much, Tim, for sharing your insight with us, but also just for the work you do and the empathy that you bring to your work here.
Thank you for allowing me to come on. I hope the audience will have a little better clarity on the difference between competency, insanity, and guilty but mentally GBMI. Hopefully that'll help sort of dovetail in with what the mental health professional said in one of your prior episodes. It's very complex, and for those of the listeners that don't believe that mental health should be taken into consideration, think back to sort of the spilled milk analogy. It does matter what the person think or could think during the time that they were doing the thing that gets them in trouble.
We want to thank Tim for taking the time to share his great insights with us.
We also want to take a moment to say that we are so grateful to have so many wonderful experts on our show. We feel exceptionally lucky and proud to have such a smart audience filled with professionals in relevant fields, as well as so many curious and engaged laypeople. To our public guests and confidential sources, thank you for sharing your experiences and knowledge with us. To our listeners, thank you for tuning in. We are honored that you are spending your time with us.
If you're an attorney with experiences in criminal law or a field related to criminal law, an agent of law enforcement, a journalist on the crime beat, or another kind of investigator with relevant experience, let us know. We'd love to hear from you. Our email is murdersheet@gmail.com. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
25 years ago, Viga ProPress disrupted the plumbing industry. Today, we're all about making big construction projects safer and keeping them on schedule. That's why we make Viga fittings in McPherson, Kansas, and ship our press systems out of massive distribution centers in Reno, Nevada, and McDonough, Georgia, to ensure that across the U.S., high-rises will always have hot water and steel mills stay up and running 24/7. Viga ProPress, MegaPress, PureFlow. The press fittings you need